Hi everyone and welcome back to Legal-Eaze, making the law accessible. I'm your host Nikhiel Deeplal and we're glad to have you back with us. As you know, Legal-Eaze is a podcast series and a YouTube channel that focuses on making the law accessible to the man on the street through various conversations with different experts in the field. We're very happy that so many of you have subscribed to the first episode, which is a general introduction to the South African legal system. And today we thought we're going to discuss a very important topic which affects each and every one of us, directly or indirectly, and that is family law, particularly marriage, divorce, and the bundles of joy often in between. I'm really happy to have with us today two experts in the field, that's Ciska Bezuidenhout and Illana, Ossin, and they're going to take us through the issues of family law. This is going to be a series, so we'll split the episodes in 2 or 3 episodes which will cover each topic. So if you don't find what you're looking for in this episode, it'll be in one of the other episodes. Again, whatever we talk about today does not constitute legal advice, so you're always advised to see a lawyer and get proper legal advice. This is just general background of the law and what it says. So welcome, ladies. Thank you for making the time to join us. Just a little bit of background. Ciska Bezuidenhout is an advocate at the Bridge Group of Advocates. She's been an advocate of the Joburg Bar for 22 years now. She specializes in family law, and she spent a significant time acting as a judge in the family court here in the Johannesburg division. She's recently been recommended for Silk, which is senior counsel, so the next time we have her here, hopefully she'll be a senior counsel. She's also an advocate for LGBTQIA plus rights, and I got it right. So she's an advocate for the LGBTQ community, and in her spare time she loves pets and often beating me in paddle. So welcome, Ciska.
Thank you.
We're also joined by Illana. Ossin. Illana's also a member here at the Bridge Group of Advocates. She's been an advocate. She was an attorney in 1999, and then she became an advocate in 2003. So she's been an advocate for 21 years. Also a member of the Gauteng Family Law Forum. Illana also specializes in family law, and she loves pets and sometimes people. So welcome, Illana. So let's get into it. Family law is often a complicated area of the law because it involves two people who start off loving each other and then sometimes not so much. It involves families as a whole, and it involves children, but it has a lot of emotional baggage that comes along with it, and that adds to the complexity of family law. And I think that's why it's an important topic for us to talk about today. So maybe we can start off on where things get rosy, and that's marriage, where everything's all, daisies and roses. And maybe we can start off there on how does marriage work in South Africa and what are the regimes?
Yes, I suppose one of the very important things is whether to marry or not to marry. But yes, those who are still idealistic and wanting to marry, of course, it is important to know that it's critical when a marriage is considered, Nikhiel, that parties must realistically start discussing what marital regime they're going to choose to regulate the proprietary or the asset consequences of their marriage. So it's important firstly to distinguish that there are civil marriages, as we call that in terms of the Marriages Act of South Africa. There's also the Civil Unions Act, which was promulgated to regulate more particularly gay marriages. And then there are also your African Customary Marriages and your Hindu and Muslim marriages. So starting with civil marriages, in terms of the Marriages Act and the Matrimonial Property Act, there are basically 3 ways that you can marry. You can marry in community of property, you can marry with the antenuptial contract, which may or may not include the accrual system. Quite often, Illana, what happens is that parties are very much in love and they skirt over this process, and ultimately when they land up in our chambers on the verge of divorce, a lot of things have been unsaid in relation to these property regimes. So it's very, very important that parties seek proper advice, what property regime will suit them best. It's important to go to an attorney, but more particularly also important to go to a notary, which is an attorney with more specialized skills in registering antinatural contracts and the like. But just briefly, in community of property, of course, means that there's no antinatural contract, and it would mean that the parties share whatever they've brought into the marriage and whatever they leave with in the marriage. Now that includes movable assets, it includes immovable assets, and perhaps we could pause at immovable assets because sometimes parties say, but the property was registered in my name. That does not matter in a marriage in community of property, so that's an important thing to take into account. And then of course also pension interests, and whether you have a pension fund with your employer, that also comes into play. And then maybe
Yes.
Illana can also deal with the ANC.
So that's the good, the bad, and the ugly, basically.
Well,
Yes.
it's not all the ugly, because the ugly that we haven't spoken about is that with an in-community marriage, you share in your assets, but you also share in your debts. So one of the reasons why an antenuptial contract could assist parties is if the parties are able to conclude an antenuptial contract before, and we'll speak about that in a moment, before the marriage, that is the only way that you could be married out of community of property. What is different in South Africa from certain countries is that if there is no antenuptial contract concluded between the parties before the marriage, the parties are automatically in community of property. So some people don't realize that if they do nothing and then get married, they will automatically create one estate with their spouse, and at the end of the marriage, whether it be death or divorce, that one estate, you could be sharing in a positive growth and in assets that are valuable, but you could likewise, depending on the spouse that you are with and your circumstances, you could be sharing in a loss. And I don't think certain parties know that, or the general population would be aware of that going into a marriage. And when the sheriff arrives with a summons to say you're being sued for your spouse's debts, sometimes there's confusion as to how that could happen if they know nothing about that debt. So that's a function of being married in community of property. As far as being married out of community property with an antenuptial contract is concerned, so as I've said, that is how you assure, or how one assures that one is married out of community of property. That is where the notary would come in, because there are various formalities that have to be complied with in order for that antenuptial contract to be properly recognized, for it to be effective. So that is why the general principle is go and see an attorney about it. Go and see an attorney who either is a notary or who has connections with a notary, so that they can properly advise you as to the various regimes. And I just wanted to say something on the good and the bad and the ugly. When clients come to see us at the end when things have gone badly, because generally we don't see happily married people, that's not our general sort of company that we keep at work, could be otherwise but not at work, those people will say, well, I didn't want to raise the issue of an antenuptial contract because I didn't want it to seem as though I didn't trust my partner, or as though it was somehow an insult. And that certainly is not a good way to go into a marriage, because just like one doesn't want to think about death, it's always a good idea to have a will. So when parties are getting married, it's prudent perhaps to think, how would this proceed if the marriage did not proceed the way we all hope it to be. So that's the one reason people might not think about the legal consequences. The other reason is that the lead up to a wedding is often rushed. So you might hear, oh, well, there was so much else to organize. So we're speaking about it on the basis that it's a priority. And in the antenuptial contract, it's not like it is in movies, where there are pages and pages of different ideas, and it's a fairly formal document that one will find with various options as to how one's property could be regulated, and advice will be given as to how the accrual system works and other systems for the ownership and distribution of property.
I think also what is important perhaps is to indicate to our viewers and our listeners when an antenuptial contract should be concluded. Because there's also a misconception that it's just a document that you can sign after you've been married. It's very, very important that these antenuptial contracts are at the very least signed on the date of the marriage or before. Because if it happens after, there is a certain window period of time within which it can still be rectified. But the problem is that if it's not, then you are in community of property. You have that regime, as Illana's indicated, and then you would have to apply to court to have your matrimonial property regime changed from that of in community of property to out of community of property. I think also the other problem, Illana, is this notion that when you're married out of community of property with the accrual, that it's still a 50-50 split in assets, but it's not so.
Yes.
So let's talk about that. Let's talk about so the antenuptial contract means that what's yours is yours, what's mine is mine, except for the accrual system.
Yes.
Am I correct in a
and
nutshell?
the accrual system should only kick in and is only applicable at the end of the marriage, whether by death or divorce. So where it differs, the accrual system is not. So let me go back a step and say that if there is no accrual that is applicable to the marriage and an antenuptial contract is concluded, then the principle is we've excluded the accrual system and we don't share in anything either now or at the end of the marriage. If the accrual system is applicable, and I should mention that unless one actually states that it is excluded, the accrual system will apply in an antenuptial contract. The accrual system is there to ensure that there is a sharing at the end of the marriage, but it's not the same as in an in-community marriage where there is one estate in operation. It is a way to balance the scales so that both parties share in the growth. So what is important to remember about an accrual is that if neither party's estate grows, it's as though it doesn't exist. It only applies if one or both of the parties' estates is greater than it was at the time of the marriage. And then the idea is that that growth should be shared equally between the parties, so that it's not the case that one party's estate has amassed a great value and the other one does not get to share in it. And in the example where one of the spouses has spent more time raising children, perhaps not working on their career as much as the other, it gives an opportunity for there to be a balancing of scales. It's not the only basis upon which the scales are balanced, but it does provide that opportunity.
And that would be a 50-50 split of the growth of the estate, I'm assuming.
Well, it's important to remember to net estate. So it can become rather technical because when a client goes to an attorney to conclude an antenuptial contract, the attorney will say, what do you want to declare as your commencement value? And that will be the value that is assigned to that spouse at the beginning of the marriage. At the end of the marriage, in the case of divorce, it will again be looked at what was that commencement value for that spouse and how much did that estate grow versus the commencement value of the other spouse, and how much did that estate grow. And one takes away liabilities. There's no such thing as a negative accrual. So if one of the spouses' estate has actually reduced since the commencement of the marriage, it is only taken that there's no growth. So the least we would deal with is nil. And it's a relative exercise. So if one spouse's estate has grown by 10 million and the other spouse's estate has grown by 10 million, for argument's sake, if they're so fortunate, the accrual there would still be nil because it's the same growth. So that would be the same nil accrual as would exist if one spouse's estate accrued by 10,000 Rand and the other spouse's estate accrued by 10,000 Rand.
So, for example, to use your example, if one estate has accrued with 15 million Rand and the other estate has accrued by 10 million Rand, the spouse who's accrued 10 million rand in her or his estate would be entitled to how much then?
That would be the 5 million rand difference, which would then be split. And I would keep the 2.5 as the greater, the spouse who's shown a greater accrual, and the spouse who has a lesser accrual, the 10 million example, would then be entitled to 2.5 million. So that each party would leave the marriage with the 12.5 million. That 5 million would be split equally.
Now, is there a possibility to exclude certain things? Say I was given an antique Ferrari that I don't want to be part of this marriage regime. Can I exclude that?
So yes, certain
actively?
assets are automatically excluded,
Yes.
such as inheritances. It's important to remember during the marriage.
Right.
The exclusions that, unless stated specifically in the antenuptial contract, the exclusions that we are talking about are excluded assets which accrue to the parties during the course of the marriage. And as I've said, there are certain statutory exclusions such as donations and inheritances that are received during the marriage, and there are certain other specific categories which are technical. But for the rest, the parties are at liberty to sit with the attorney and to look at whether there are any other benefits, other assets such as pension benefits, which often land up being a very big part of the estate, various, or a property, or as you say, an antique that's been inherited before, any number of assets, whatever worries a person. I'm not sure if this should form part of the marriage, the accrual in the marriage. Just one brief pause to perhaps also make the whole concept a little bit more concrete. When one is married in community of property, one shares in the physical asset. And what I mean by saying that is that one owns the asset together. And it is as much the one spouse's asset as the other spouse's asset. So Ciska mentioned the immovable property, where it is registered in both, it would be registered in both names, or even if there was a mistake and it wasn't registered in both names, it's owned jointly by the parties. When one is married out of community of property with the accrual system, what the spouse is entitled to who has an accrual claim is a monetary amount, not the asset itself. And so it's important to remember that what the claim is a claim which will come about at the end of the marriage to share in the growth from a monetary point of view, not to share the asset itself, the antique, the jewelry, the actual house. And that is why it may be that there is no accrual, even if there are various assets in the other spouse's estate that appear on the face of it to have value, if there are as much, if there's as much value in a liability sense. So when it comes to exclusions, what one is saying to the attorney if one wants to exclude certain assets, one is saying, I don't want the value of that asset as it is now or as it grows later to be included in that monetary calculation.
But what is also important, Nikhiel, is often this mistake is made where the parties calculate a certain commencement value by listing the assets and the values that they currently have prior to the marriage, and then they exclude exactly the same assets. Now that's almost double accounting, and the difficulty that you have is that parties must be very cautious of that reality, that whatever your commencement value is, or whatever that commencement value comprises asset-wise, cannot be excluded as well.
Okay.
Because that would affect the consequences of that antenuptial contract, and in some instances even the courts have found that the contract is to be set aside, and that the effect of that is that the parties are married in community of property. And that's why it is so important to really go through these particular aspects very, very carefully with a notary.
Yeah, and I think that's what people must do. But there's a we hear this in movies, Hollywood movies all the time about the prenup. Now, is anything different between the ANC and the prenup? I mean, most people just know the prenup. What's a prenup?
It is the same thing, but as I've said before in the movies, it seems to be, I'm not sure, there's a concept that it's a very lengthy document and you can prescribe behaviors and you can prescribe sanctions for if your spouse doesn't behave the way maybe you want your spouse to behave. We don't go in for sort of moralizing in.
But we have encountered that
We
before,
have.
though, in certain antinuptial contracts where the dogs have been provided for, and what is it? A commitment for a period of 5 years before
And-
the antinuptial contract
and
will become
consequence-
effective.
Sorry, and
So
Ciska,
yes, those are
consequences for infidelities
Yes.
in the antenatal contract, our courts tend to steer away from those. And it's unlikely that putting in clauses that are too sort of, the only word that comes to mind is a way out, or way beyond the accounting principles that we're speaking about would be upheld. That's not really the purpose of an antenuptial. It's not to control your spouse or to dictate to your
Yeah.
spouse, or
Because-
to regulate maintenance. Even that has been
But that's
rejected.
the thing, is that that's what I just wanted to mention now, is some of the antenuptial contracts before dealt with by the courts, in fact, excluded maintenance for your spouse after divorce. And that was also found to
Right.
be an unenforceable clause in the settlement agreement.
That's very
I beg your
interesting.
pardon, antenuptial
And I think the fact that you talk about infidelity, we'll touch on that later on. But I want to move on to African customary marriage quickly before we go to Hindu Muslim marriages
Yes,
for this episode.
yes.
So, Ciska?
African customary marriages, of course, are regulated by their own act, the Recognition of Customary Marriages Act. And the commonality between civil marriages, for the want of a better word, and African customary marriages is, of course, that the default position for an African customary marriage is also in community of property. But of course, the African customary marriages requirements are quite different. Amongst others, which again there's a bit of a commonality between the Marriages Act and the African Customary Marriages Act, is that you have to have reached the age of majority. You have to be 18. And there must be consent between the two spouses for the marriage to be concluded. Of course, within an African customary context, usually that type of marriage is a marriage between families.
Yeah.
It's not necessarily between the individuals. And then the third requirement relates to whether or not the customs of that particular tribe who marries have been met. Where it becomes tricky, though, is where you have two parties falling in love from different tribes. It's also important to bear in mind that even if both parties are from the Zulu tribe, for example, the Zulus in a certain region of our country or certain province of our country would have different customs as opposed to Zulus of KwaZulu-Natal, for example. Gauteng Zulus have different customs. So the courts throughout the way that the African customary marriages have been approached have found that there's no rigid way of determining whether or not all those requirements have been met, especially the customs of a particular tribe. And because the courts have said customary marriages and the law of custom is a living law, which means it just changes from generation to generation. So in that sense, it's important to bear in mind that certain customs, such as the slaughtering of a goat, might not necessarily be acceptable in other customs. Whereas the negotiation of lobola, which is one of the integral and critical parts of our African customary marriage, in some tribes, payment have to be made in full. In other tribes, payment does not have to be made in full because they don't want to see or to consider that the bride is some commodity. So every single customary marriage would have to be considered on its own merits. And of course, there was also this whole argument of whether the handing over of the bride is a requirement, especially in a westernized sort of environment where the parties start cohabiting together, even before they've been married. I mean, where do you hand over the bride? is the question. But the other important thing, and Illana can amplify on what I've just quickly touched on, is that for an African customary marriage to be valid, it need not be registered with the Department of Home Affairs,
Right.
which is a stark difference to the marriages concluded in terms of the Marriages Act. It's a requirement the Department of Home Affairs must register those marriages. But I would really encourage parties to have their customary marriages registered, because in the event of death or in the event of divorce, that box has been ticked. Because then there is no dispute regarding whether or not there was a valid customary marriage, which often happens then between families.
And in terms of polygamous marriages, you'd register, maybe just talk on that quickly. How does that work? Do we register one or both?
So that's what I wanted to say, is
Yeah.
that it's important for each one to be registered. The difference in a civil marriage is that the moment a client wants to talk about any rights based on that marriage, the first question would be, let me see your marriage certificate.
Yeah.
And for a civil marriage, that is one where one starts and ends as far as the date of the marriage and the proof of the marriage. With a customary marriage, one has more than one marriage at the same time that is recognized and that is valid, and each one would have to be proven on its own merits. And the Act does deal, and we're not going to go into the distribution between the various wives to a polygamous marriage, etc., but the Act does recognize that polygamous marriage. So it's already fairly complex that the question is whether or not the customary marriage exists. It becomes further complex when there's more than one customary marriage in existence at any given time. And I wanted to pick up from what Ciska was saying, is that usually with a civil marriage, there's one day when the marriage happens. And even though there may be various pre-wedding celebrations, the wedding itself is fairly easy to isolate, the marriage, etc. When it comes to customary marriage, there's a progression of various customs usually. There will be gifts between the families and various parties, and when I say parties, I don't mean people, I mean celebrations. There'll be various celebrations, there'll be various lobola negotiations before certificates sometimes are given, sometimes not, between the families. And the handing over is very often the last step, and there were cases where the handing over was emphasized. And then, as Ciska was saying, the idea that it's a living custom, that one can't be too rigid about what constitutes a customary marriage, was important, because there were various other significant parts of the custom in concluding the marriage that was looked at. But what is important to remember for viewers is that sometimes an individual who is participating in these celebrations may not realize, all right, at this point, that would be considered the marriage concluded. Now, why that is all the more significant is that that marriage is concluded in community of property. So that person has now joined their estate, joined their assets, joined their liabilities to another person, and unlike the civil marriages, doesn't have a certificate that the marriage officer gives them, and doesn't say, here we go, this is confirmation, you are now married today, you are now sharing one estate. And only afterwards, in the unfortunate event that the marriage is broken down, looking backwards, do we have to put together the pieces of the timeline and say, all right, that was the day that this joint estate was created between spouses to a customary marriage. And that can lead to some confusion after the fact when spouses are carrying on their lives as normal, as though they're not sharing one estate with their spouse. So it's just something to be aware of when something comes without a little piece of paper and a certificate to remind us where we are.
Yeah.
I think it's also important then also to bear in mind that, of course, an African customary marriage, the property regime, the default property regime of in-community of property can also be changed by way of an antenuptial contract. One often have clients talking about the traditional wedding and then the white wedding, which is then the civil marriage that is concluded after that. But of course, also in an African customary marriage, you don't need the white marriage or the white wedding, for example, to conclude an antenuptial contract. But it also becomes tricky in the sense that once the African customary marriage has been concluded, then you're no longer technically dealing with an antenuptial contract, because that means a contract concluded before a marriage.
Yeah.
You're now dealing with a post-nuptial contract, and you're changing the property regime. So the law is still a little bit divided on what the legal position is currently. There are a few cases going on at the moment on that aspect. But it's also very important for our viewers to bear that in mind.
So just in a nutshell and very quickly, because this topic is quite complicated, African customary marriages, and maybe we'll do an episode on that and go into further detail.
Yes.
But okay, let's go to Hindu marriages, Hindu and Muslim marriages, and we'll come back to the post-nuptial contract.
Yes, unfortunately, the talk about Hindu marriages is a very short one. And that is that Hindu marriages are still not recognized in South Africa, which is very, very unfortunate. We are still actively trying to have Hindu marriages recognized as well. So at the moment, Hindu marriages are non-existent in South Africa, unfortunately, as opposed to your Muslim marriages that have now come out of the starting blocks, and there is some recognition for Muslim marriages.
Correct. So we're attaining some recognition of Muslim marriages, which I want to speak about in a moment. I just wanted to make one point again about African customary marriages and what Ciska was talking about with the timing of an antenuptial contract and an African customary marriage. The really important message, and I apologize if it sounds as though we are belaboring the point, is that it's really important to speak to an attorney while contemplating or considering, an African customary marriage particularly, so that the person can get some advice as to, I am involved in labor negotiations, etc. I want to be married out of community or property. How do I achieve this? It's not something that I would recommend that a person tries to do on their own. And if it's not my place to start recommending various legal aid bodies, and I don't presume to do so, but I know that attorneys are expensive, but there are also law clinics at various universities, etc. And it's not the sort of area that one should try and go without the legal advice.
But I think the lesson is that do it before anything starts, because you're just not sure when you are officially married, which is a the tricky circumstances one might find themselves in, and I think that's quite important.
So don't get caught off guard. Don't be caught in the white wedding dress, as we're talking about the white wedding, without having received the advice, or the tux, or whatever other traditional garb one wants to wear in the marriage. All right, so returning to Hindu and Muslim marriages, before I talk about the marriage, and it may be a little bit starting on the negative, but South African law has an interesting element to it, which has placed it way beyond some of the other countries, is that there are, in Muslim and Jewish marriages, the decree of divorce, that it's called ecclesiastical, which is a very old way of saying the religious body, will give a divorce order in Muslim marriages and in Jewish marriages for the divorce order. And what makes South African law different from many other countries is that if the parties have been married according to Jewish or Muslim law, and there is a religious marriage in existence, the spouse getting divorced can insist that a religious order be given before or after, within a reasonable time, the civil divorce. And we'll talk about divorce in this one other episode, but it gives some recognition already to the status of religious marriages, and it becomes important because it gives a certain amount of power to the party in a religious marriage to regulate the status of their religious marriage and their civil marriage, so that the two are not at odds, that they're not different, and that gives enormous peace of mind to spouses in a religious marriage. So I just wanted to mention that from that point of view. In Hindu marriages, my understanding is that it's not as difficult to get the recognition as to what the divorce order should be. There are fewer issues around that. So it pertains more to the Muslim and Jewish marriages, where the order of divorce can be more of a technical and contentious issue. Muslim marriages, up until very, very recently, as in a couple of months ago, for years, there have been various groups lobbying Parliament towards and against the idea of recognizing Muslim marriages, and there have been various cases that have dealt with it. And it's naturally beyond what we're discussing to go into this in any great detail. But to say that there are certain groups of, or certain categories of Muslim marriages today that receive the same recognition that any South African civil marriage would, in a similar way to the way we have described African customary marriages, if they are still in existence, or were still in existence as at May of this year. And then the Act which has changed that, which is an amendment, has dealt with the various ways that marriages which have already been terminated in accordance with religious law, which of those marriages would be on equal footing. Well, it's not exactly an equal footing, but which would be recognized according to South African law. And it does get rather technical. Once again, it's the sort of issue that I would refer people to an attorney, but it is a huge milestone for Muslim marriages, and it's a huge milestone for the recognition. And we will get to this, but one of the ways that Muslim marriages have been dealt with up until now is to say these people in a Muslim marriage who may have had a marriage for 40, 50 years, it's as though they are just cohabiting as what other countries would say is a common law spouse. And I know we're going to get to that because we're going to debunk that concept and say there is no such thing as a common law spouse. But that is how the various ways that we've dealt with it. So there's a distinction made in the new amendment about marriages before December 2014 and after December 2014, and that's why I don't want to go into the technicalities that have been terminated by the Muslim decree of divorce, which is known as a talaq. And there has to be, again, a sort of a conjunction between what has been recognized religiously and does that fall within the scope of what we recognize in terms of South African law.
I think you've left off on an interesting topic, the common law spouse. Let's touch on that before we round off.
There's no such thing. Spoiler alert. There's no such thing in our South African law.
But why, Ciska? I mean, people live together for a long time. Does that mean when it ends, it just ends? Or?
You know, Nikhiel, it's been, again, going back to what I said earlier about African customary marriages and people rather living together than getting married sometimes. There is some draft legislation in the pipeline providing for certain proprietary and maintenance consequences of a cohabitation relationship. But the courts have been very rigid, and rightly so, I suppose, to some extent in that regard, because courts are saying, but you can regulate whatever marital relationship there is. You could even limit your risk by marrying out of community of property so that you don't share any debts, and hence a court will then, under those circumstances, give the protection under the Marriages Act and the Matrimonial Property Act. The problem, however, is that in a cohabitational relationship, it's also sometimes very hard to prove that a cohabitational relationship existed and for how long it has existed and what the requirements then would be, and when you actually do qualify for a share in the cake, so to speak, and maintenance. Of course, then there are other remedies available to those kind of relationships which we can sort of briefly touch on, and that is a universal partnership claim. But there are also quite few requirements to be met in that regard. But for the time being now, although there is some movement on the horizon, be very careful just to move in together and think you have a claim after that.
Be it in South Africa, either you're married or you're not. It's quite simple. And I think it's important to know that it's always considered, what is the term? It's a status matter. But the status as to whether a person is considered a minor or a major, these are important aspects of one's legal personality, that this is how the world will see a person legally. Marriage is a status, not a status as in a luxury vehicle status, but a legal status. And because it carries those implications, our law is very careful to recognize, are you a married person or are you not a married person? And therefore, any kind of grey area in between becomes very tricky. And as Ciska says, how do you prove it? So when does one consider a cohabiting couple to have reached that level of commitment, that commitment should get legal recognition? If one of the parties should pass away, should that person who's been left behind on the couch, should that person receive benefits? Now, why I say on the couch is, one person will say, we've been in this committed relationship and we've been living as though we're husband and wife. The other person will say, are you being serious? That person's been sleeping on my couch as a lodger for 2 weeks. So there can be a huge discrepancy in terms of, and how does one measure a committed relationship, and when does one say that relationship started? Which anniversary do you recognize? So those questions become very tricky if one puts a monetary value to it. When the other spouses are, or the other partner rather, non-spouse, is saying, I want to make a claim to an inheritance, or a claim to half the property, or a claim to maintenance, and there's no marriage certificate to speak of. And today, where it's more modern and where more people are opting to not be married, creates more work for lawyers, because we don't have that very first certificate that I spoke about earlier. And so yes, there are all these movements to look at bills and draft legislation, but those have been around for years. We don't have any indication when those will be made into law. So at the moment, what we're left with is small areas where on a piecemeal basis there is some recognition of cohabiting partners in areas that are as specific as a road accident fund. What is the status? Inheriting without a will, what is the status? The maintenance that surviving spouses, that was a recent decision from the Constitutional Court, what is the status? And even in there, it was difficult to define the relationship.
So it's possible, but just very difficult to prove.
Yes, because it also goes to show that the courts are, to a certain extent, albeit in a very limited way, recognizing that it's becoming quite a commonality for people to live together. I've every so now and again found in my practice that parties in fact conclude a cohabitation agreement, a written agreement.
Okay.
But that is a contract regulating the relationship between the parties. Which is far removed, of course, or a far cry from antenuptial contracts and marriages and that sort of thing. But that in a sense, I suppose, would be a contract that would have to fall on all fours in relation to the validity of the conclusion of the contract. And you can't then contract in that agreement anything that the law does not allow you to contract on. So it remains a risky business.
Lastly, does that also apply to the engagement phase? Is it a similar sort of concept for the engagement period?
Engagements have another concept attached to them, which is called breach of promise, and that's another whole common law. We've inherited that. It's changed and also evolved a bit with the times. So there are questions about what are the implications if one person breaks off an engagement. And looking back in the case law for many years before, there was a certain compensation given to the dumped party, for want of a better term, and usually it would be the woman who would make the claim on to ease her feelings that she has been so publicly humiliated through this broken engagement, and that person was compensated because their marriageability was considered, and I'm saying this is a sort of an old-fashioned way
of course.
Of regarding things. So there was some compensation given for that, and then one looked at, and one can still look at it, but this is just a sort of common sense that remains in our law. If the other person who was party to the engagement has put down money that has been lost as a result of the broken plans, one would look at that in a common sense way and say, I've put down the deposit on the hall, etc., etc. That comes back to simple laws of contract, well, not simple, but basic principles about, has somebody caused the other person to suffer loss, and was it wrongful? So those were the two ways that one looked at the breach of promise heading, was the actual financial loss and then the hurt feelings. And I would venture to say that today there is less of a concept of it being such a humiliation, and so it's less emphasized, that hardship. Not to say that emotionally one doesn't have that, but we have therapy today as well. So
And Facebook.
we have social media to express these things. But I think that makes the hurt feelings worse, in my opinion, is having Insta.
Because I mean, to be
Tinder
honest,
might solve some of the problems though. But
Or create new ones.
I cannot remember when last time I had a breach of promise claim, and when the courts allocate or award damages, it's far less than the rent that you would, or the deposit that you would pay on a venue.
Yeah.
I do want to talk about the ring. We often get asked about the ring.
Yes, tell us about
Especially the engagement ring. So the general principle is, once they've been married, the parties, whether the marriage lasts a short time or a long time, that ring has been given as part of the marriage. It is the person whose ring it is. So usually we're talking about the valuable one being the woman's diamond ring or stone ring. It's become her ring. Whether or not it's part of the accrual, part of the joint estate, I'm not going to get into that, but it's hers. When her engagement is broken, there is some discussion, and there are different circumstances under which that person would be expected to return the ring or keep the ring. But that is, I just wanted to make that distinction between the marriage actually going ahead versus the engagement being broken off. So that I did have recently, and that's why it did come to mind, because somebody has their grandmother's expensive inherited ring with sentimental values. They give it thinking that this person is going to keep it forever and be married, and then they break off the engagement and they want Granny's engagement ring back.
Well, if someone wants a ring back, we know where to go now.
Not necessarily.
No, I think that's a great summary of marriage, and I think that this is a great place now to end this discussion. I think we've touched on some key elements, from community of property to the anti-nuptial to the accrual and African marriages, Hindu marriages. So it's quite a nice way you guys have packaged it. So we appreciate that. And in the next episode we'll be talking on divorce, the other side, the flip side of the coin. So thanks Ciska, thanks Illana. Thanks for watching. As you know, this is a part of a series that we'll be doing. The next episode will be focused on divorce. And in the interim, please like, share and subscribe, and share the video and the link to anyone who you think might need it, or to the general public and your friends and family. We'll catch you on the next episode. Again, I must thank my team. That's Advocate Anthony Gotts, SC, and Zinche and Gwenya for all their help. And we'll catch you on the next episode. Thanks.